In my role as chairman of the practice group, I want to thank you for all attending and filling the room, and to the overflow room as well, I suspect. For those of you that are interested in our practice group, as you know, it deals with federalism and separation of powers issues, and we're always looking for new blood on our executive committee. You can send a note to Julie Nix or Dean Reuter or me if you're interested in that, and we'll tell you all that's involved. And we welcome that as also your ongoing participation in our podcasts and our writings and the programmings that the practice group sponsors. And with that, I will now introduce it to Judge Brennan on the Seventh Circuit Court of Appeals, who's going to moderate this panel. Thank you very much.
Thank you, John. The topic today of our panel is horizontal federalism, the less well-known sibling of the two dimensions of federalism in our constitutional system of separation of powers. Less well-known, of course, than vertical federalism, its allocation of power between the federal government and the states. The Constitution presents two structural features that place in tension the allocation of power among the states. The first is that states are equal in stature. Second, the Constitution defines state power in the aggregate rather than individually, which complicates efforts to define state authority. The founders, having lived through the Articles of Confederation, were well aware of the potential for interstate discord. Certain Federalist Papers, number 6 by Hamilton, number 5 by Jay, and number 45 by Madison, warned of the states' propensity to undermine and antagonize each other. In the Confederation, which preceded the Union, states asserted their independence by retaining their own monetary systems, erecting barriers to regional trade, and controlling their own militias. So interstate friction has been with the country since there have been states. Our panel today will approach a number of questions about how the behavior of states may or may not induce friction. From the Federalist Papers, some of the questions that they're going to approach are: what parts of the Constitution are designed to control the states interfering with each other? When and how may states legitimately project their power into other states? What are the different implications of a nation being divided up into states? Is there a distinction between federalism and decentralization? And if there is a distinction, what is it, and is it useful anymore? Is horizontal federalism a contradiction? How does the Dormant Commerce Clause factor into thinking about how a state can project its power into another state? Our prompt in the materials identifies one example of interstate friction recently decided by the U.S. Supreme Court in Franchise Tax Board versus Hyatt. I've also been charged with laying down a challenge to our audience today. Many conservatives think reflexively that if a state does it, then it must be justified. So part of our debate today is about what things a state does that are not justified. Our distinguished panel is made up of 4 scholars with substantial writing and thinking in this area. I'm going to introduce them now. Their full bios are in the materials. So just a short introduction on each. John Baker is a visiting professor at the Center for the Constitution at Georgetown University Law Center and professor emeritus at Louisiana State University. He has taught at the law schools at a number of universities, including Oxford, Catholic University, Tulane, George Mason, Pepperdine, and others foreign and domestic. For years, Professor Baker taught the Federal Society Separation of Powers course with the late Supreme Court Justice Antonin Scalia. Edward Rubin is the University Professor of Law and Political Science at Vanderbilt Law School. Professor Rubin joined Vanderbilt Law School as its dean. Previously, he has taught at the University of Pennsylvania Law School and at the Bolt Hall School of Law at the University of California, Berkeley. Professor Rubin is the author of numerous books, including Federalism, Political Identity, and Tragic Compromise with Malcolm Feely. Third, we'll hear from Ilya Shapiro, who's the director of the Robert A. Levy Center for Constitutional Studies at the Cato Institute and publisher of the Cato Supreme Court Review. He has contributed to a variety of academic, popular, and professional publications. He has testified before Congress and state legislatures, and he has filed more than 300 amicus curiae briefs at the U.S. Supreme Court. Then we'll hear from John Eastman, the Henry Salvatori Professor of Law and Community Service and former Dean of the Chapman University School of Law. Professor Eastman is also the director of the Center for Constitutional Jurisprudence, which is affiliated with the Claremont Institute for the Study of Statesmanship and Political Philosophy. Each of our panelists will speak for 8 minutes here from the rostrum. We'll then ask the panelists to respond to each other's remarks in a roundtable fashion. After we move through a couple of rounds of comments, we'll move to questions from the audience. Let's begin with Professor Baker.
Thank you, Judge, and thank you for covering an introduction that allows me to elaborate a little bit but spend more time on other things. And by the way, it's difficult to read on this podium with no light on here. Okay, so picking up from what Judge Brennan said, the reality is we don't often associate the word horizontal with federalism. But to understand our system, which often we don't fully understand the integrated structure that Judge Brennan was talking about, we have to begin with the notion that the Federalist begins with, and that is that federal systems are inherently unstable. That was the problem that they faced. Back then, of course, federal and confederal meant the same thing. But because of the way we redefine things, federal has come to mean, for us at least, what the American constitutional system is. But because we tend to think of federalism in terms of the vertical relations, we often, as the judge indicated, ignore the horizontal relationships that actually were the reason why the Constitutional Convention met in the first place. We think of it just as about commerce. Yes, it was about commerce, but it was about more than that. So while we may be very concerned as we are, as conservatives and libertarians, about the abuse and overreaching of power by the federal government, we have to realize that the same thing, but to a lesser extent and confined to certain states, is happening. And the danger in all of this is that it will produce the situation that the framers understood. That is, federal systems have a tendency to do one of two things: explode or implode and consolidate power. We have two different tendencies in this country right now. One, the centralization of power, and the decentralization of power. You may not be aware, but there's an active secessionist movement in Hawaii and Vermont. Not that they're going anyplace likely, certainly not with North Korean missiles aimed at Hawaii, but it is a concern in terms of the way we approach certain issues. First of all, understanding the structure. Is there a lot of booming coming off the mic? Okay. So I want to, now I can't even hear myself. Okay. Thank you, John. Okay. First of all, I want to talk about, that didn't do any good. Trying to help me. Look, three things I want to talk about. The fact that there is this inherent instability. Two, what did they do about it? What they did about it was to remove the control over borders by the states, but to add to it the obligation of the federal government to protect the states. And three, what are some of the examples today where states are abusing their powers? That is, projecting their sovereignty, which is not full. They have residual sovereignty. They lost full sovereignty by losing control over their borders. It's no longer a treaty system. It is a federal government, which is our invention. We seem to have forgotten its significance sometimes.
John. You're not getting picked up in the other room, so just try and do it 2 inches away.
I'm doing it.
Yeah.
There you go.
Yeah,
You
that's
got
it. Perfect.
Who's
right there.
responsible for this
I
sound
know.
system?
I know.
Okay. Excuse me while I pick this up. I can see the light.
Is there a light switch?
There should be a light switch. Look, there are certain things, I'm trying to get the article. It's Article 4, Section 4. There are certain provisions from the Articles of Confederation that are horizontal federalism that are taken over. Full faith and credit, privileges and immunities, extradition. They were all strengthened. They were given enforcement power that didn't exist before. That is the vertical dimension that is there to enforce the horizontal relationship among the states. You add to that diversity jurisdiction, which many federal court law professors who teach federal courts don't understand, and judges don't understand the importance of diversity jurisdiction. It is about horizontal federalism. It is about retaining the relationships among states. It's about controlling states from projecting their jurisdiction and their laws to other states, which they have a tendency to do in some states. But the federal government also has the obligation to protect state borders, not just against foreign intervention or invasion, but against each other. So for instance, a case that you probably spent less than a nanosecond on in constitutional law is a critical case. It's called the lottery case. Anybody remember the lottery case? Okay. Only one person remembers this, so that means that nobody really studied this. So why is the lottery case important? Because Congress got it right. The court got it wrong. Why? Now, if you remember the case, it was about lotteries in a foreign country in Central America. But that was not the case. It was all about Louisiana. That's why I know about it. Louisiana at the time was the only state in the country to have a lottery. The rest of them had gotten rid of them. Why? For religious reasons, they got rid of them. The Lottery Act was aimed only at Louisiana, but what the Congress did was not to outlaw lotteries. They simply said, you can't ship lottery tickets out of the state. Why? The other states could not block the lottery tickets from coming in. They had lost control of their borders. It was commerce. It could come in. They couldn't do anything about it. And of course, Louisiana got 93% of its income from the lottery from other states. So one state prohibits lotteries and another state undermines all the other states. That can't be. It was a proper role of the Congress to protect the other states against the rogue state. That's part of Congress's job that it has forgotten all about. Why? The Supreme Court said in the lottery case, you did a good thing. This is a bad thing, lotteries. And if you go and you read in the Congress afterwards, they said, and these are progressives, they're saying, the court said we did a good thing to deal with this immoral thing. And guess what? The progressives took off with it, and that is the beginning of the over-federalization of criminal law and the vertical imposition on the police powers of the states. All because the court got it wrong, even though Congress got it right. And generally since then, we have forgotten the relationship that should exist. Time, you can't hold me at time after this mic thing. Okay.
I'm giving you 2 more minutes.
We'll negotiate.
Right.
Okay, so what are some of the abuses that are going on today? I'll just break them into several categories. One is climate change. What's that? Okay.
You don't like?
Climate change, illegal aliens, obviously, and the national popular vote. Climate change. The former Attorney General of New York, when he launched his litigation or investigation in the grand jury against Exxon and other companies, announced to a press conference that because the Congress would do nothing about climate change, that these 17 attorneys general were going to solve the problem of climate change. That was quite a daring operation on his part. How could he do that without projecting his power beyond its legitimate bounds? And then California cities have taken it up. Cities and counties have taken it up with all kinds of litigation about the rising seas and blaming all this on the oil companies. These are national problems, if they are problems. But they're not problems that a state can solve, and for you to get into this business, you are usurping the powers of the federal government. And how about the immigration problem? There's no obligation on the part of states to do what is a federal job. They can agree or not agree to cooperate with ICE. That's up to the state. But it's quite a different matter to undermine federal law, to encourage people to come. And it's not only a problem about federal law, it is a census problem and a House of Representatives problem and an electoral college problem. In California, citizens are leaving in large numbers. And yet, California population keeps going up. I wonder where they're coming from. And for decades, we have been including in the reallocation of House seats everybody physically there, even members of embassy staffs. I have it documented. That interferes with the power of other states. Third thing, national popular vote. How many people know about this movement? Well, good, at least some of you. You better wake up. This has been going on for a number of years. Some years ago, we had a panel on this, but they've gotten to states in the District of Columbia representing 195 electoral votes. They only need a handful more of blue states, and they'll hit the magic number 270. The whole thing is to have a compact, which the Constitution prohibits unless you have congressional approval, which they don't provide for. They say, well, we might get it. We will have a constitutional crisis if they get to 270 votes and you have another close election and there is the attempt to force a change in votes where people in a state who voted by a majority for one candidate are told that their votes are going for the other candidate because the other candidate got a majority of the popular vote. These are crises that are brewing, and they threaten the structure of our government, and it's not just the federal government. The federal government is doing things it ought not to do, but it is not doing things that it ought to do. Thank you very much.
Thank you, Professor Baker. We'll move to Professor Rubin.
I'll try to make this work. I'm not as stentorian as John, so I hope I can make the mic work. But thanks for having me. If we think about federalism and extraterritoriality, obviously there are two considerations. One is what is extraterritoriality, and the other is what is federalism. I want to talk a little bit about what federalism actually is. So my colleague Malcolm Feely and I have made a distinction that we think is important between federalism and decentralization. Decentralization is a managerial policy where an institution delegates certain authority to subunits of that institution. So this is something that's a general organizational feature. Most large firms, for example, are decentralized. And there are various principles for decentralization. You can have decentralization on the basis of function. So a firm might divide itself by production, marketing, public relations, and that sort of thing. A firm might divide itself by brands. General Motors is famous for this. Or a firm might divide itself by geographic areas, dividing the country or indeed the world into regions and having a subunits be responsible for each region. In politics, the division tends to be geographic in nature. And so you have political decentralization being the central government giving certain powers to geographically defined subunits of the nation. Now, this is not the same thing as federalism. And the reason it cannot be is that every nation in the world other than the Vatican is decentralized to some extent on a regional basis. They all have subunits and usually localities underneath them. It really is very difficult to govern everything from a center. But the point of decentralization is that this is a mechanism that the central authority is using to govern more effectively and carry out its own policies in a more effective manner. Federalism involves the creation of definitive rights by the subunits against the center. Now, why would any central government agree to lose control over portions of its jurisdiction to the authorities in a sub area? And basically, there are two reasons that we know from history. One is that's the only way to unify the nation or unify an organization. You can think of the EU, for example, as a highly decentralized polity. The other is because the nation may be unified, but there are groups within that nation that have a different political identity and that are unwilling to associate themselves with the nation as a whole. I mean, the example that comes readily to mind at present is Spain, where you have several different areas, the Basque Country and Catalonia, where people speak a different language, have a different history, and are demanding a degree of autonomy. Now, we come to the United States, the subject, our country of interest. It's not clear whether, when the United States was formed, it was formed as a national system that simply decentralized power to the states. That was, after all, the British colonial model that we inherited, or whether it was a federal system where a group of states allied with each other to form a nation. There are plenty of historical support for either view, and in fact, this was one of the major battles that was occurring in the pre-Civil War period. But we know what's happened in the post-Civil War period, which is the United States has developed a uniform political identity and has become a unified nation. So that federalism, as it existed or may have existed in the pre-bellum period, is now vestigial. What we have is a decentralized system that really reflects the unified political identity that we've achieved and is a very substantial political achievement of the United States. What does this mean for territoriality? Well, it means that the principle of geography, the principle of administering through geographic subunits is the one that should control. And that means that the issue needs to be thought of primarily in managerial terms. So this would suggest that incidents or occurrences in each state should be governed by that particular state, and that we should be very skeptical of state power being extended beyond the boundaries of the state. So, for example, I'll just pick something non-controversial like assisted suicide. If a state prohibits assisted suicide, but another state permits it, and people from that state travel to the other state to avail themselves of this, it should be the other state's law that controls, because the occurrence is happening in that other state. Or to pick another example, equally uncontroversial, of abortion restrictions, the same would apply. If people travel to another state to avail themselves of different abortion rules, it should be the other state's rule that apply, because that's the managerially based version of or the managerially based solution to the problem. Now, interestingly, this is an example where if you take a states' rights view, you basically get the same results. I don't know exactly what it means to say that the states are sovereign, because the whole theory of sovereignty related to a uniform regime that had plenary authority. But assuming you want to say that and think in terms of states' rights, okay, so the state from which the citizens depart has rights, but so does the state to which the citizens then travel. So we're talking about two conflicting sets of rights. I think the only result of that is you're going to get a more confused analysis because you're dealing with something mystical rather than something that is A, practical, namely the managerial principle, and B, reflects the reality of political identity in the United States today. Thank you.
Thank you, Professor Rubin. I'll hear from Ilya Shapiro.
All right, I'm going to try to solve this microphone problem with a different method here. I have one on this side, one on this side. We'll see how that works out. What's that? Yeah. Is there a light here? Is there a light switch here? I guess not. I'm going to have to read regardless in the dark. Well, it's great to be with you all here. This is actually my first time on the National Federalist Society stage. I feel like the Crash Davis of FedSoc, been toiling in the minors, probably spoken to most of your local chapters over the years, and finally get the big call up to the show. And you know, they awarded me all this fruit salad of Brezhnevite ribbons to go along with it, so it's very nice. It's kind of distracting. And they put me on a panel of horizontal federalism, which to me is a misnomer, as is cooperative federalism, by the way, because federalism, by definition, is the idea that you separate sovereign powers vertically between nation and state sovereigns, just as you separate them horizontally into three branches. So I get what horizontal means. The judge did a nice way of framing the discussion, but I think it's inapt because, for example, Maryland and Virginia weren't splitting the same chunk of sovereignty. They're just geographic delimitations of a broader thing. What we're talking about here really is interstate relations, which encompasses comity, full faith and credit, privileges and immunities, and the regulation of interstate commerce, including its dormant capacity, as I'll go into. Not that I have a better name for this panel, although its focus is the extraterritorial effects of state regulations, as well as state lawsuits, global warming, compacts, John Baker mentioned the national popular vote, which to me, all of which is subsumed with interfering with interstate commerce. The write-up to this panel mentioned the Hyatt case from this past Supreme Court term about extra-state taxation, but I think there was an equally or even more important case from last term that's relevant here, and that's the Tennessee Wine and Spirits versus Thomas case, where the court, by a 7-2 vote, struck down a state requirement that to get a liquor license, a retail liquor license, you have to have lived in the state for a number of years, or if you're a corporation, all the shareholders need to be in the state. Braden Busek wrote an excellent piece. I don't know if Braden is in the room today, or hopefully he's at the conference. He's the head lawyer at the Beacon Center in Tennessee. For the Cato Supreme Court review this past year on Tennessee wine called "That's Why I Hang My Hat in Tennessee, Alcohol and the Commerce Clause." And so I want to focus my remarks on the Dormant Commerce Clause, in part because this is one of the few areas of law where I depart from that hero of federalism, Justice Thomas, and the only area I've yet discovered where I depart from Justice Gorsuch. And I lean heavily on Braden's exposition and analysis here. Courts have interpreted the Commerce Clause to have a negative component that prohibits states from discriminating or placing excessive burdens on interstate commerce. I liken it to the constitutional equivalent of implied statutory preemption, which is, I think, inherent in our constitutional structure. It's kind of like judicial review. They didn't need to spell out that Congress can regulate interstate commerce, and also when it doesn't, states can't interfere with it. It's assumed, it's implied. The dormant commerce clause arises from the concern over the burdening of interstate commerce, and indeed preventing interstate trade wars, which are not easy to win, was one of the original purposes in convening the Constitutional Convention. As the court said in Hughes versus Oklahoma in 1979, by granting Congress authority over interstate commerce, the Constitution aimed to avoid tendencies towards the economic balkanization that had plagued relations among the colonies and later among the states under the Articles of Confederation. Dormant Commerce Clause analysis falls under one of two categories. The first is legislation that's per se invalid. The second considers incidental burdens and applies a balancing test developed in Pike versus Bruce Church. But there's no clear line between the two, and under either analysis, the court has held the critical consideration is the overall effect of the statute on both local and interstate activity. Two types of laws are considered per se violations: those that are facially discriminatory on out-of-state businesses and those that regulate extraterritorial conduct. The defending state has to overcome a presumption of unconstitutionality by demonstrating that the burden serves a legitimate local purpose that could not be adequately served by available non-discriminatory alternatives. This is some sort of heightened scrutiny. It's not quite rational basis plus, it's not quite strict, but these are the showings that kind of overall the courts grapple with. And these cases have historically cropped up in subjects like fish, trains, trucks, which along with booze are all great subjects for country songs. So I encourage any of you academic members to let your pun flag fly in all of these sorts of literatures. For the plaintiffs who brings an extraterritorial challenge, the question is whether the practical effect of the regulation is to control conduct beyond the boundaries of the state, as the court clearly said 30 years ago in Healy versus Beer Institute. There really are a lot of alcohol cases here. The Commerce Clause generally protects against inconsistent legislation arising from the projection of one state regulatory regime into the jurisdiction of another. For example, a state can't force an out-of-state merchant to seek regulatory approval in one state before undertaking a transaction in another. And this extraterritorial analysis requires a court to consider not only the consequence of the statute itself, but how the challenged statute may interact with the legitimate regulatory regimes of other states and what effect would arise if not one, but many or every state adopted similar legislation. Again, you hear echoes of this anti-interstate trade war rationale. Extraterritoriality cases actually make a small part of Commerce Clause jurisprudence, although it's growing in part because of the types of regulations that John Eastman will talk about coming from California, but also the rise of the internet age. As states increasingly try to regulate perceived problems online, extraterritoriality challenges are apt to increase as well. Given the borderless nature of the internet, any effort to regulate is doomed to, quote, project its regulation into other states and directly regulate commerce therein. Lower courts are all over the place on this question, so I think the Supreme Court is going to have to weigh in. But states who wish to regulate online businesses would do well to tailor those laws to remain in state. And I should note that taxation and regulation are different with respect to interstate commerce. The compensatory tax doctrine allows even facially discriminatory laws to survive so long as they're designed only to make interstate commerce bear a burden already borne by intrastate commerce. And you saw that in the Wayfair case a couple of terms ago. But this is different than the regulation of interstate commerce. Under a recognized line of cases, states may not require an out-of-state party engaging in national transactions to qualify to do business in the state, absent evidence that the party has sufficiently localized. This comes from the Allenberg Cotton Company versus Pittman line of cases from 1974, which I think is an under-theorized, and often judges look at this case and they really don't know what to do with it. Maybe it's even a third category on top of the per se and the Pike balancing types of cases. Finally, when a facially neutral law has the effect of actually discriminating against out-of-state businesses, the court reverts the level of scrutiny it applies to facially discriminatory measures, and so the burden, again, is on the state to justify the local benefits and the unavailability of alternatives. Now, the Dormant Commerce Clause has its critics, of course, as I've mentioned, who fault it for being constitutionally atextual. Could other constitutional provisions do the work that to invalidate, for example, Tennessee's durational residency requirement that came up this term? Justice Thomas has suggested the Import-Export Clause or the Privileges or Immunities Clause of the 14th Amendment. I certainly endorse that. I would also add privileges and immunities from Article 4, which both played subparts in the Tennessee wine case, but ultimately weren't ruled upon. The obvious question now surrounds the inevitable line drawing in determining where the predominant effect of a law is protectionism, not the protection of public health and safety. And there's a big circuit split as to whether mere in-state protectionism of industries is a sufficient rationale for these types of laws. The Fifth, Sixth, and Ninth Circuits are correct in saying that protectionism is not a sufficient rationale, whereas the Second and Tenth Circuits are wrong in allowing base protectionism in state industry to prevail. The larger debate about the Dormant Commerce Clause remains after Tennessee wine. Somewhat surprisingly, the dissent, Gorsuch and Thomas, actually don't discuss the Dormant Commerce Clause there. Their dissent was purely on the 21st Amendment. But the looming conservative argument over alternative constitutional theories will have to wait, and for its part, the Dormant Commerce Clause is alive and well, both with respect to extraterritoriality and protectionism and other issues that I've raised, with the majority's vigorous use of the doctrine gaining 7 votes, including the newest Justice, Brett Kavanaugh. Thank you.
No, I didn't. I've got one in my pocket if you need it. So can the soundboard guys we're getting a ton of feedback up here. Can you just adjust it just slightly so maybe we can get that fixed? I'm going to take issue just briefly with Ilya on the Dormant Commerce Clause. The issue mainly there is who gets to decide, Congress, which I think the Constitution sets out, or the courts, which I don't think it does. I do think the Tennessee Wine and Spirits versus Thomas was an aptly named case, since it's against Thomas's views on the Dormant Commerce Clause. And it's now against Thomas and Gorsuch. It was against Thomas and Scalia before. But that'll be next year's panel, and we'll get you back and we'll have that on board. Look, a number of years ago, let me start with this. I don't think whether the Dormant Commerce Clause analysis is correct or not, there's an exception in the Dormant Commerce Clause for states when they're acting as market participants. And it's that market participant loophole that has led to a lot of the interstate conflict that we're now seeing, and is a threat to the kind of independent policy judgment aspect of state sovereignty that I think is really at issue here. So a number of years ago, California, San Francisco, which owns the San Francisco airport, decided to use the fact that it owned and could then decide the leases for the gates at its airport to set international airline corporate policy, not just for their operations in California, but worldwide. And if you didn't change your corporate policy for wherever else you were flying, you would not be allowed to fly into San Francisco Airport. And that seemed to be a projection, not just of California's policy judgment about particular issues, but of San Francisco's policy judgment of particular issues into corporations that were grounded in Delaware and their operations not only in other states, but around the world. It threatened the very idea of independent sovereign states setting their own course for policy, but it also meant that California was in some measure deciding international or foreign policy for the United States using this hook of market participant by owning those gates at the San Francisco airport. And we've seen this thing break out a lot. And it's one of the exceptions to our normal understanding of the full faith and credit clause that I want to focus on. Every state has to give to each other state the full faith and credit to the public acts, records, and judicial proceedings of every other state. But there's always been an exception understood in that when giving credit to another state's policy judgments would undermine the state's own policy judgments. And so I want to pick up on Ed Rubin's comment about if a state wants to allow for assisted suicide and I go there to get assisted suicide, I'm probably not going back to my home state to do anything further. But it's a different rule if I'm going to get an easy divorce from Las Vegas that was contrary to the policy in my home state, and then I go back to that home state, and I've now completely undermined the marriage policy of that state. So I think it's important for us to look at these extraterritorial reaches on whether it's altering the policy of the sovereign state within its own jurisdiction. And we've got a spate of these issues that are coming up recently. California, in 2016, banned state agency travel to Kansas, Mississippi, North Carolina, and Tennessee. This was triggered by North Carolina's policy judgment that they didn't want men identifying as women going into the women's showers in their schools or at their public pools. Attorney General Becerra added to that list Texas, Alabama, Kentucky, and South Dakota in 2017, driven by Texas's decision to let religious faith-based welfare organizations follow their own religious conscience in adoption proceedings and what have you. Now, this is a market participant exception to the Dormant Commerce Clause because California didn't ban all of its businesses from engaging with those states. It only banned its government employees and government travel to those states. And yet it is trying to project its policy judgment on those states to express a disagreement with those states' policy judgment. I think we've got to revisit that exception when it's being used so extraterritorially. Otherwise, we're going to be back to the very conditions that led to the Commerce Clause, the Full Faith and Credit Clause, the Constitution itself, the Annapolis Convention. In fact, I'll go back one step before that. The Mount Vernon Conference in 1785, everybody remember that one? It led to the Mount Vernon Compact between Virginia and Maryland on how we would control transport along the Potomac River. These things were designed to protect against states trying to interfere or counter the policy judgments of other states. Now, maybe there's no way to deal with that. Or maybe we're in for a set of reverse trade wars based on those different policy judgments. Here's what happened when Los Angeles decided to boycott all Arizona and Arizona businesses after Arizona passed SB 1070, its immigration bill. The commissioner of the Arizona Corporation Commission wrote a letter back to Mayor Villaraigosa. Said, Mayor Villaraigosa, you explained your support of the boycott as follows. While we recognize that as neighbors we share resources and ties with the state of Arizona that may be difficult to sever, our goal is not to hurt the local economy of Los Angeles, but to impact the economy of Arizona. Our intent is to use our dollars, or more specifically the withholding of our dollars, to send a message. The commissioner then said, I received your message, Mayor Villaraigosa. Please receive mine. As a statewide elected member of the Arizona Corporation Commission overseeing Arizona's electric and water utilities, I too am keenly aware of the resources and ties we share with the city of Los Angeles. In fact, approximately 25% of the electricity consumed in Los Angeles is generated by power plants in Arizona. If an economic boycott is truly what you desire, I'll be more than happy to encourage Arizona utilities to renegotiate those power agreements so Los Angeles can no longer receive any power from Arizona. I'm confident that Arizona's utilities would be happy to take those electrons off your hands. If, however, you find that the city council lacks the strength of its convictions to turn off the lights in Los Angeles and boycott Arizona power, please reconsider the wisdom of attempting to harm Arizona's economy. People of goodwill can disagree over the merits of SB 70. A statewide economic boycott of Arizona is not a message sent in goodwill. Now, I think what's happening here is we're going to see more and more of that point-counterpoint quid pro quo economic fighting if we don't start trying to limit the states of trying to influence not just their policy judgments, but interfere with the policy judgments of other states within those other states' own jurisdiction. The Los Angeles quickly backed down, not on the power grid, but when they realized that it was an Arizona company that managed its red light traffic camera cash cow generating system, and they quickly exempted that from that. Now, one other thing here, and I'll close with this. A lot of this latest market participant-driven boycotts from California is based on California's spending power as a governmental agency. But a lot of those funds, given California's near bankrupt status, an increasingly large amount of those funds aren't driven in California, but are federal funds. So one of the ways you could start to deal with this is for Congress to get back in and say you can't use any federally funded program to launch extraterritorial reaches into the policy judgments of your sister states. Maybe that's all we can do, but given the current dynamics of federal spending, that may be an awful lot. Thanks so much.
For our next stage, we are going to have the panelists talk amongst each other. You've heard about the constitutional strictures on the dangers that can be produced through interstate friction. We've heard about the decentralization, the contrast with federalism. Ilya, no one will ever accuse you of being a Brezhnevite, don't worry. We've heard about the Dormant Commerce Clause and then the market participant loophole to that Commerce Clause. Who would like to begin about a comment on each other's presentations here?
All right, I'll say something. I mentioned that federalism is vestigial in the United States. I think to some extent our discussions are indicative of why that's the case. And the reason is no one really believes in it. What happens instead is it gets used for political purposes that people really care about. So when there's a liberal government in power, conservatives like states' rights and are big fans of the kinds of impediments to government, to central power that the states can offer. When the reverse is the case, when there's a conservative government in power, like the Bush administration or the current administration, then all of a sudden liberals become big fans of states' rights. And I think this is indicative of the fact that basically federalism becomes a kind of way of dressing up more controversial positions in what looks like a general norm, but is in fact something that has become, although it certainly had a role in our political rhetoric at the beginning of the Republic and has continued to have that kind of pedigree, that it's no longer something that people are committed to on its own terms.
John?
I don't think you understand. I don't think you understand federalism. I don't know whether you've read Federalist 39, but the term federalism is an oddity in many ways. I mean, as Madison says, we are a compound republic, and the name federalism, as we have it, is a splitting off from confederalism, and it is this complicated structure that we've been trying to talk about. And if you wish, I can show you that during Republican administrations, I've opposed state things as well. And this is why you and many, especially in the media, use the term states' rights. Federalism is not states' rights, okay? The Constitutional Convention was largely called to control the states. I mean, that's why we have an independent judiciary. That's why we have these provisions that we've been talking about. It is a balance. That's why it's unstable. And we were able to strike a level of stability, but before the Civil War, we know there was the pull that led us to the Civil War. Since then, we've gone the other direction. Okay, there's an inherent instability. Now, your discussion about the managerial points have certain merit to it. But the premise under it is the administrative state, that everybody from Washington is administering, delegating down, having the lower levels. I mean, that's really the model in France. The districts do what they're told to do, and that's really what you're talking about. But in this country, they still can only do that to the extent that it's tied to money, basically, or the Commerce Clause. And when it's just money, states like Wyoming and other places that don't want to do it and can afford not to do it, they tell Washington to take a hike. And that is federalism, when the states in areas where the federal government goes beyond its power and they have the ability to say, take a hike, they're able to do that.
I want to push back on the other ground, Ed, on your comments, and I'll use as the example, the Gonzalez versus Raich case. I'm no longer from California, but I was at the time, and I hated the California policy. But I fought hard against what I thought was federal overreach to alter California's local domestic policy about marijuana. Because I thought that was California's decision to make, and it had nothing to do with whether I agreed with the national policy or not. I was consistent in saying California had that judgment to make, and I think a lot of people are. Do we bring biases that sometimes are a little below the assumption? Yes, but the real question is, when there's something that's obviously against your preferred policy outcome, and yet you nevertheless stick with the principle, I think it's important to make that distinction.
Ed, do you want to respond?
Yeah, well, I mean, I think I'm not trying to suggest that everybody is unprincipled and everybody is governed by political considerations, but I think that's the overall mood in the country. I mean, I think that's the basic way that politics has played out over the course of not only the last several decades, but really, the last, the 20th century and into the current century, that the predominant view has been predictable based on the substantive policies, which are, after all, the things that we truly care about and we're truly committed to. I think the issues of states as independent entities as opposed to a nation with a unified political identity is something that did get solved basically at the time of the Civil War. And I think it's in a way a remarkable achievement of the United States that we have forged out of such a disparate population and a decentralized origins, a real national unity and a real sense of collectivity as a nation. I think that's something very valuable, and I think it's something that should be protected.
But ironically, this national unity is breaking down because of the centralization of power. Because in such a large and diverse country, the aggregation of power in Washington, and then within Washington, it's skewing towards the executive branch, pushing everything into the administrative state, has created this zero-sum game rather than allowing different parts of the country to have their own policy views. If California wants to kill its own economy by having all sorts of different regulations, so be it, but it's only once it starts regulating out-of-state companies that it becomes both a policy and a constitutional problem.
John?
Yeah, I was going to say this, much the same thing. I mean, it is a great accomplishment, and we had a certain balance at a point, but today, if this ideological divide continues in Washington, nothing's getting done, and the danger is ultimately our enemies understand this. Certainly China understands this, and they are manipulative. They know how to play us, and at some point there will be a crisis, and unfortunately in a crisis you have to have unity. And if Congress isn't functioning and things aren't getting done and the life of the country is at stake, you will have one-person rule come out of it if the Congress doesn't get to a point where it can actually begin to govern again.
John, did you have a comment that you wanted to? One of the prompts here was on the Franchise Tax Board Hyatt case, and Justice Thomas gets into a historical examination in that case of where he thinks the state sovereign immunity comes, and then transmits it, and it does a rather brief stare decisis treatment on Nevada versus Hall and reverses it. John Eastman, with regard to that, does 20 years of litigation that comes down to that determination. Your thoughts on whether it's correct or incorrect?
Well, I've long been a critic of the 11th Amendment sovereign immunity cases, but not on this point. And my criticism has been on Chief Justice, the late Chief Justice Rehnquist's view that states retained their sovereign immunity even over federal question jurisdiction. That's the area over which, under the plan of the convention, they were specifically no longer sovereign. And keeping a sovereign immunity that dealt with diversity questions versus federal question made a lot of sense to me, and they went a different path. But the issue in Franchise Tax Board was different. Were the states obligated to recognize the independent sovereignty of the states? And here's just one passage from the case, and I'm going to change the word sovereign immunity to just sovereignty to make it not just about immunity from court action, but respecting the policy judgments of the separate sovereign itself, which I think is more directly to the points I'm trying to make. Although the Constitution assumes that states retain their sovereign immunity, switch out sovereignty, except as otherwise provided, it also fundamentally adjusts the states' relationship with each other and curtails the states' ability as sovereigns to decline to recognize each other's immunity, switch out sovereignty in their own courts, switch out just as a matter of policy judgment. I think the principle inherent in that case, when I apply it to the broader attempts to extraterritorially alter the policy judgments of other separate subsidiary sovereigns, that's where we get the kind of friction that's exactly the interstate commerce friction that led to some of the constitutional clauses in the first place. And what's going on now, it's different in kind, but I think it needs to be responded to in much the same way, and that there has to be some curtailing of the ability of states to try and reach into other states to alter their policy judgments.
I think that's right, and I think it goes to a principle of equal state sovereignty and comity. I mean, whether you call it full faith and credit, and the inverse of that to grant an immunity. The anti-federalists were actually quite influential on this point, and they're cited in the Hyatt case. Preview of a panel that I'm on at the Western States Conference at the Reagan Library in January, just on that subject. What else do I want to say?
Is the court getting it right in Wayfair and Tennessee Wine? Are they picking up on those things?
Well, I disagreed with Wayfair initially. Cato filed a brief on the other side, but as I read more and more, I don't know. I mean, the court's disagreement was all about the remedy, right? Even the dissenters said, yeah, this physical place requirement isn't correct, but we leave it up to Congress to change because of stare decisis, essentially. So the position that I had filed on really gained 0 votes at the court, so maybe I need to rethink that. I don't know, but there are other cases where I'm happy to be on the other side of a unanimous Supreme Court. This one I'm not as invested in and willing to learn more. I think on Tennessee Wine, though, I think it's correct. Each state does have its own powers, its own sovereignty, not so much rights. States' rights, I think, has always been a misnomer, and I just think it's a healthy development to have states pushing back on the federal government, but that doesn't mean they can equally push back on each other. And I'm thinking here, John raised the marijuana example. After Colorado legalized for recreational purposes, I think it was Oklahoma and Nebraska sued Colorado over its regulatory scheme, saying that it was spilling crime over into their respective states, which is kind of a bizarre claim to make, given that they're welcome to police their states, and it's not like Colorado is taking out ads in the Omaha airport saying, come to Denver for your Rocky Mountain High or something like that.
They are.
Well, if they do that, that can be stopped.
Right.
But otherwise, Nebraska and Oklahoma's beef is with the federal government, and they're saying you should be enforcing federal law, which is a wholly different kind of case than trying to sue your sister state about the impropriety of your own domestic laws.
John Baker.
I did file also on the Wayfair
Mike,
case.
Move your microphone over. Thank you.
I did also file on my own behalf in the Wayfair And I filed under the import-export clause, and I tried to bring to their attention, and it may come back because they've sent it back down and it'll come back again probably. The South Dakota law applies worldwide. Worldwide. And you know how they intend to enforce it? If you violate their law, they're going to file a declaratory judgment act in a South Dakota court. And if you don't show up, they're going to ding you. Okay, well, that may work in the United States. But I pointed out, I keep getting these things I order that I think are from an American company, and they're coming from China, but they're not really located in an American base, and they come through the American postal system at the subsidized rate getting from China so that they can ship it cheaper from China than you can ship it from here. How do you think you're going to enforce this against China? In other words, my point is, they're not thinking about this in a federal context, in a sovereignty context. You have no power to enforce this. And the import-export clause says you have to get Congress's permission for this. Now, I didn't open up and go back to what Justice Thomas was saying about the import-export among states. I didn't want to fire it up that much. But this clause, as Justice Thomas has pointed out, and is consistent with Hamilton, despite the fact that he wanted free trade within the country. They thought about this in terms of taxes, tariffs. What we call today in terms of protectionism is what? Non-tariff trade barriers. But that's for Congress. Hamilton left it to Congress. Why? Because these are matters over which we can disagree. These have to be worked out. There's no absolutely perfect position on any tariff issue because there are different interests involved. So because we've forgotten these things, we're going to, in the internet age, really screw it up until we figure out you've got to look at this whole thing structurally. Interestingly, Justice Gorsuch mentioned that he wasn't necessarily going along with everything. I was somewhat surprised that Justice Thomas didn't say more. But it may be that when it comes back, and now that Justice Kennedy's not there may be a totally different result.
Professor Rubin, have we forgotten it? I suppose to use your word vestigial, is it more than vestigial, or is it vestigial as a result of some type of evolution that's happened from your perspective?
When you say forgotten what?
The history of the individual state sovereignty and the friction that resulted. Have we just moved beyond that, or from your perspective, is it something that could be resurrected?
Well, I think as long as you have authority being given to subunits of a system, you're going to have inevitable conflicts. There were conflicts between Buick and Oldsmobile and Chevrolet in General Motors. In other words, authority of any kind is going to produce conflicts, and I think the question is, what are the principles by which those are resolved? It's sort of interesting that I think the panel, despite a certain amount of ideological disagreement, seems to be all cognizant of the fact that the predominant issue here is that we have a unified nation and that the authority being granted to the individual subunits within it has to in some way be contained within those units, and that the flow of national commerce and the relationships, the power of extraterritoriality needs to be limited in the interest of the fact that it is a unified nation.
John?
But the Constitution doesn't grant the states any powers. It limits their powers. That's all it does. Any, quote, powers it gets from the federal government is a money transaction and under the spending clause. And the Marshall Court held repeatedly, and Congress ignored, that they couldn't allow states to enforce federal laws. So over time, yes, we've grown into an administrative state, and that's what the struggle is. Our constitutional structure versus this overlay that's been put on it. And that's where, as far as most of us are concerned, that's where the real struggle is.
I want to just add one more point. Look, I mean, one of the big theoretical flaws with the Dred Scott decision, I focus on theoretical flaws because there are a whole lot of other flaws with the decision, but the theoretical flaw is that the result of that decision allowed Missouri to project its policy into not just other territories, but into other states of the Union. And that meant that the states could not set their own policy. And you can take any of a number of contemporary issues and see the problem with that. Take gun-free school zones, or take the wonderful gun mandatory ownership rule of Kennesaw, Georgia from a number of years ago. If I can figure out how to project that policy that I've made locally into other states, I create a huge problem. And it's the projection that flows from not respecting other states' policy judgments, not giving them full faith and credit, if you want to go back to that clause, although I don't think that clause directly addresses this kind of reverse manipulation that we see going on now. But it will create massive tensions cross states that will make it impossible, in the end of the day, to have independent states as independent laboratories of self-government, and it will drive everything toward a national one-size-fits-all solution. And one of the beauties of our system is because we've not had that, different states could go their own directions and people could self-select where they found the best policy choices. When you go to a one-size-fits-all, we're going to end up in a civil war, as equally divided as we are. This safety outlet of the states has proved essential to our success. And these kind of new policy judgments, these projecting policy judgments, I think are going to undermine that to catastrophic consequence.
Let's see this in the context of the national popular vote question that we were talking about earlier. Is there any power or authority among the small states to be able to push back to say our ability here is going to be so vitiated that our role within the historic constitutional structure is gone?
Well, very, very few Americans have any idea that this is even going on. And we debated on a panel several years ago, as I said here, the founder of the movement, and they've got a lot of money, and they have paid a number of Republican consultants to convince Republicans that this is, a very democratic move. But that's what got us the 17th Amendment, too. Populism, where they equate pure democracy as being consistent with our structure. It's not.
2 points here. One, practically, given modern political circumstances, if the National Popular Vote Compact succeeds, and if it withstands the inevitable legal challenges, which I think are going to be very strong, and I'll talk about those in a minute, think about where modernly this would play out, because most of the states that are joining the compact are the blue states, which means the thing would come to a head when the blue states' votes are not aligned with the national popular vote. Or let me put it in terms of the last election. California's electoral votes are going to go to Donald Trump if he had won the national popular vote, because they're the states that have joined the compact. Now, how long-lasting will that compact be if New York and California have to cast their votes for Donald Trump? Because that reality right now, that's the only way it's going to play out in the foreseeable future. The legal challenges, the constitutional challenges, I think are profound. One of them is the power of the states to set the method for choosing their own electors on its face textually has no limitation. That cannot possibly be right. California could not say, we're going to let the Sultan of Brunei choose who our electors are. Right? Having given the vote to California electors, the 14th Amendment or 15th Amendment right to vote would mean you can't then pass off the result to somebody else. But more profoundly, this compact will alter the role of other states that have not joined it. And I think that's why it's absolutely required that Congress approve it. But even if they do, states are still allowed to say, we're going to let our legislature choose the states. And therefore, they would not be any part of any national popular vote, and yet would be excluded entirely from the decision of who the next president is going to be. That projecting of power from the compact states to the non-compact states is exactly the constitutional infirmity that we've been talking about otherwise. And I think for that reason alone, it will not get upheld at the end of the day.
Any comments on that topic? Well, before we move to questions from the audience, I do want to give the opportunity for each of the panelists, if there's any final comments or reactions they have to anything that's been said thus far, to weigh in. All right, everyone's got their say.
You know, I actually have
Ilya?
a question for John, and not like a critical or a gotcha question or anything, but in the context of state action and boycotts, are there legally cognizable claims with either the city or the state saying we won't have government travel to particular states because of their policies, or the state government saying, to contract with us, you can't deal with those states, or something like that?
Under existing doctrine, if the state tried to regulate its private business and says you can't go do business with North Carolina, that would be a violation of the Dormant Commerce Clause. But if the state...
But you don't like the Dormant Commerce Clause.
I don't like the Dormant. I'm accepting that as the premise. But under the existing doctrine, when the state does it with its own resources as a market participant rather than a regulator, they can do it all they want. And I think what's this extraterritorial projection of policy judgments using the state's resources has to, because it's different in kind than the type of thing we were looking at when the market participant doctrine was developed. And I think that's going to require some revisiting or reconsideration to deal with this new problem.
All right, thank you. These comments obviously have engendered some questions from the audience. Feel free to line up at the microphones. 3 requirements, though. First, please give us your name and affiliation. Second, I'm going to exercise the moderator prerogative here that if you give a long preface, we need to move from a declarative sentence to an interrogative sentence at some juncture. Third, if there's a particular speaker...
Are semicolons allowed?
They are. If there is a particular speaker to whom you're addressing your question, please say so. Otherwise, fold that into the beginning of your question that's going to the whole panel. Hans, let's start with you.
This question is for John Eastman. John, I want to take you from the 30,000-foot level down into the practical level, and the question is to you because you deal with election cases. And I'm wondering whether any of the issues you've discussed, projection of power, giving credit to what goes on in other states, should prevent a state from removing from its voter rolls an individual that they discover has been registered in another state. Because there are some judges now who have ruled that there could be a valid reason for someone to be registered in more than one state, which even if it violates that state's law. Thanks.
That's Hans von Spiskowski from the Heritage Foundation. Yeah.
So I think if states are deliberately not removing people from the voter rolls in order to alter the effect of elections, particularly national elections, particularly to mail the narrative on a national popular vote, creating a propensity for fraud, it's similar in kind to the problems we've been talking about. I have to give more thought to the full implications of that beyond that, but I'll just give one example. We cease being California residents, registered in New Mexico, and I can't for the life of me get California to remove me from the rolls. I'm waiting to see if somebody votes with my name on those rolls, and then I'll have a new cause of action, but it is a problem.
The second microphone here.
I wanted to ask about a state regulation of kind of the chain of commerce before it's sold in the state.
Could you start with your name and affiliation?
Devin Watkins from the Competitive Enterprise Institute. And I'd like to suggest that there's a spectrum and find out where that line is between what's allowed and not in your minds. On one side, imagine a state that says, we won't allow you to sell a product in this state unless it was produced with the labor that was provided at least $15 an hour. And on the other side, imagine a state that says, we won't allow you to sell chicken in this state unless it was kept below a certain temperature. Both of these, in some sense, regulate the entire life cycle of that product, even outside of the state. But where can we draw the line between what is allowed in that sense and what is not?
Actually, Tennessee wine opened the door to this discussion in somewhat, because some of the new ground that case broke is about police powers and the limits of police powers. And there's more deference and more legitimacy to a state law or regulation that's passed with respect to public health and safety rather than other kinds of rationales. And so the thing about, it doesn't make a product healthier or safer to say that it's the people who produced it were paid $15 an hour. So that one probably wouldn't fly. That could be seen as in-state protectionism, or either of your industries that have to fulfill that regulation, or projecting your policies, trying to put them onto other states. With the hot or cold chicken, I don't know. It depends on whether there's a legitimate scientific basis for that. And I would adopt a presumption of unconstitutionality until and unless I can be convinced that as a judge, as a legal analyst, that there's a real health and safety police power reason for it.
I think that's right. I mean, the courts have largely punted on that issue because at the margins it's very difficult to tell what's a valid health and safety regulation and what's not. California's got a new law that requires 50% of all public corporation board members to be women. And if they want to then use that law to project that to any corporation that does business in the state, you can see the extraterritorial reach, and it has no connection with health and safety. It's got to do with a California policy that may be contrary to a more free market oriented policy in another jurisdiction, and it's that extraterritorial reach to try and alter the policy judgments of other sovereigns that I think is the problem. But if it was, if we had pretty good proof that free-range chicken are healthier than non-free-range chicken, and California says you want to sell chickens here, they got to be free-range, even though they're being grown in Nebraska or wherever they are. But you got to make the connection to the health and safety. You can't just assert it. I think that because otherwise you're imposing your policy judgments elsewhere.
Just one quick thing about taking a managerial approach to this as opposed to a sovereignty approach is that you then aren't making absolute judgments, but you're making relative judgments in comparison to other policies. So there's a kind of a market failure analysis to justify regulation, and that would suggest, for example, that health and safety regulation and certain kinds of regulations against fraud would stand better than price regulation, which does not have a market failure justification. So the affirmation cases where a state tries to essentially protect its or project its pricing policies into other states would, I think, be subject to much more intensive scrutiny than health and safety.
Let me just a quick addendum to that and look at California's policy on free-range chickens. The ban on chickens that are raised not meeting California standards, I think, projects their policy judgment. But if they were simply to require a notification on chickens sold in California, did this meet California's free-range standards or not, they would not be forcing the other state to change its policy, but only affecting that which occurred within California. And maybe that's the compromise solution that respects the two competing sovereign policy judgments.
Front microphone.
Yeah, Paul Kamenar, a Washington, D.C. attorney. This is for Professor Baker. John, I did not read the lottery case. I can understand why you did, being from Louisiana. But you raised it in terms of the context of states not being able to control their borders and have to rely on the federal government. But I did recall a provision that I Googled at the table, and that's Article 1, Section 10. It says in pertinent part, no state shall, without the consent of Congress, engage in war unless actually invaded or in such imminent danger as will not admit of delay. So I don't know, this is one exception to that rule, and also could this governor of Arizona arguably say these illegal aliens were being invaded, and the federal government's not doing enough?
And put a wall on the western border?
Right.
Exactly. But there you go.
No, I argued that to officials in Texas several years ago.
Oh.
So that's not a new argument for me.
Okay, I just wanted to point out that that is an exception to the borders, that you needed the consent of the
No, but
federal-
the assumption is the federal government should get there as soon as possible.
Right. Yeah. But they can't engage in war with that kind. Okay, fair enough.
Back microphone.
Tony Napolitano, Arizona Attorney General's Office. The Supreme Court has exclusive jurisdiction over cases between states and exercises discretion over whether or not to take those cases for review. Should that come to an end when there are disputes between states where they have no other forum over issues that might otherwise be casus belli, or is there some other means of rectifying these?
I, for one, think the Supreme Court should take more cases, and this is one aspect of that. Should be forced to take those cases.
Well, having had a case denied the motion to proceed, I agree that they should have to take the cases. But it's not just the Supreme Court. Federal courts figure out ways whenever they want to say they don't have to take a case. Unfortunately. But again, that's up to Congress to punch back. And I say punch because read Federalist 51. Each of the branches is supposed to, when necessary, to clock the other one if necessary. And there are a few things.
That's about 3 paragraphs in, exactly.
No, look, anyway, I could go on. I won't.
Maybe what we just need is a constitutional amendment to add to the end of every provision, and we mean it. And then that would just fix everything.
Yeah, it doesn't work. It doesn't matter.
Front microphone.
Hi, Mario Loyola, Competitive Enterprise Institute. Ilya, I want to commend you on your clever California joke, so this question is for you. Several years ago at Texas Public Policy Foundation, I did a study of state antitrust enforcement and came to the conclusion that state antitrust enforcement would be greatly improved if state antitrust enforcers stopped doing everything they're doing and did something as unrelated as possible to antitrust law. But there's one exception, it seemed to me, where state antitrust enforcement could actually do some good, and that is if instead of protecting their constituents from interstate competition, state antitrust enforcers actually went after each other's cartels. So I would love, for example, to see Texas sue California over California's raisin marketing program. Now, those lawsuits are generally blocked by Parker versus Brown, the second worst decision of 1943. But in a very interesting case, which actually goes to some of Professor Rubin's points several years ago, North Carolina versus FTC, we saw that the Supreme Court, even the liberal justices on the Supreme Court, are willing to at least tighten the state action doctrine of Parker versus Brown. So my question is, what hope do we have for getting further refinement, shall we say, or curtailments of Parker versus Brown to allow states to go after each other's cartel creation?
Well, I think that dovetails with the previous question, right? To sue another state, that's an original claim in the Supreme Court, and the court would have to entertain that. I mean, I think that is thinking creatively. I think that would be good. I don't know why you'd necessarily need a state to be the plaintiff, though. You could have another, a business, neighboring business that's harmed by that state's cartel, and perhaps that's a way to push on the whether on Parker v. Brown or whatever else, or dormant commerce clause, or privileges and immunities. All of these doctrines kind of come together at that point without the extra complication of having one sovereign against another. But I'm just spitballing.
Well, the principal thing, though, is you got to get rid of the notion that
Mark, participate.
well, anti-competitive behavior that is protecting of states-owned businesses is a legitimate governmental purpose. IJ and the guys over at Cato have been doing a lot of good work on that, either litigation or scholarly, or both. And that note, and that's what the circuit split you talked about earlier was.
Yeah.
I mean, there's a clear right answer. That's not a legitimate governmental purpose. I mean, you go back to Madison and the discussions about monopolies and all of that. I think we've got to really engage on that issue to the point we win it.
That's interesting. What do you think about Alaska not allowing farm fishing and Washington having Washington-graded apples?
No.
Would you say they couldn't do that?
It's a problem. But I would go back to Corfield. If the state owns the resource, if they own the oysters in the seabed, if you go into the public trust doctrine, they don't have to share that with everybody else. If they own the resources of their K through 12 public education system, they don't have to share it with everywhere else. Pyler versus Doe is wrong on that. But more broadly, beyond whether the owner and they're the regulator, I think you do have huge problems with it.
It's funny that you talk about...
Could they do a certification system where you opt in or not, and you get to be the certificate that this is a Washington state apple?
Well, wasn't it... I think the Seventh Circuit got wrong the Wisconsin butter grading case, right? So, but on Washington apples, there's the inverse. Hunt versus Washington State Apple Advertising Company, 1977, right? The court, this was a North Carolina law that required apples to display only the U.S. Department of Agriculture apple grade, facially neutral, but it hurt out-of-state interests, and especially Washington apple companies that graded on the Washington scale. And because the law could achieve the goal of protecting citizens from confusion over the quality of apples through other means, the court struck it down.
Yeah, and you were for that?
Yeah.
Okay, me too. So go back. Would you be against Washington being able to do what it's doing that caused North Carolina to do what it did?
Well, I think butter grating is utterly ridiculous, and apple grating is rotten to the core.
Further to the pun flag, right? Professor Lawson.
Gary Lawson, Boston University School of Law, although this is really a Yale-sounding question. So, so brace yourselves.
As a Princeton and Chicago man, I take a point of personal privilege on that.
It's going to sound spacey, but it may actually help explain why some of these issues seem so difficult, both doctrinally and politically. Ed, you mentioned the notion of a national identity. Let me just throw out one anecdote. My son, just from college, tells me that virtually all of his classmates, just in casual conversation, discuss people who live in red states as horrible, awful, vile creatures, and they want them all to die. And they literally want them all to die. So I wonder if that national identity thing, that's a boomer thing, as they would say. And that's just not there anymore. And there are all sorts of good reasons not to be surprised by that. We're all raised on Federalist 10 and the Extended Republic. Every human being before James Madison thought that was garbage. Maybe they were right, or at the minimum that there's an optimal size for an extended republic that we blew out of the water a long time ago. Here's the question mark. Is the problem from all of these doctrines that the country's just too damned big?
Well, first of all, I don't think they want me to die. And the reason is that I live in Nashville, and Nashville is democratic. So the point
That's
is...
much too subtle and sophisticated.
No. It's not, and this is the reason why. We're all familiar with the colored map of the United States, and that map does not show regions of being with different colors, and it certainly doesn't show states of being different colors.
Cities.
What it shows is a sea of red with islands of blue. And so basically the political configuration in the entire country is one where the rural areas tend to be more conservative and the urban areas tend to be more liberal, and the particular alignment in the state has to do not with where the state is, but with that relative alignment of rural versus urban forces. And so I do think that these issues are being debated on a national level, and that it's people's alignments with the national issues. So I would suspect, for example, that a conservative in California feels better represented by the senators from Texas than by his own senators, and vice versa for a liberal in Mississippi. And so I do think that's the basic political dynamic in the country. As far as the United States being too big, it goes back a little bit to something John was saying about terminology and about the way we think about a government. So we call ourselves a democracy, but remember, democracy was a term that the founders were rather shy of, and it's because they were thinking about ancient Greece. And of course, Aristotle in the Politics has exactly that point, that you cannot have a functioning polity beyond a certain size. That's what representation is all about. Representation was a medieval practice that had nothing to do with democracy, but was adopted by the revolutionary regimes at the end of the 18th century precisely to deal with this question of size, and it does effectively. And so I would just endorse what John was saying about the fact that the legislature needs to be a dominant force, a leading force, and a force that gets things done. I think the tendency to for legislatures to shy away from decisions, which we've seen in Australia, which we've seen in Ireland, which we've seen in Britain, of course, and we see here in terms of our sort of legislative deadlock, needs to be resolved, and we need to move forward with the mechanism that we have developed for dealing with very large polities, and that is representative government.
Gary, I don't think Madison was wrong at all. I think he was very, very right, and he's still right today. The problem is part of his solution has been eclipsed by technology. Here's what I mean. His teaching on factions is all about preventing any one faction from controlling the central government. That's key. So, because he knew we wouldn't all get along. We're not a homogeneous country. We never were, and we never will be. So the question was, how do you deal with this? And the whole business in Federalists 9 and 10 is about the large extended republic. And what's the key? The key is spreading out people so they can't communicate. Right? Well, that's dead. The communication problem is the problem. We're all in each other's faces now on cable television. That has broken down the Madisonian fix. It's a technology fix problem.
I want to push back on the other direction. That is, I think it's not a denial of national identity politics that creates that phenomenon. It's national identity on steroids. They have decided what the national identity ought to be from their own circles, and they want to impose it on everybody else, or they should die, right? And that, until we allow for the outlet of different visions. I mean, why is California getting to set transgender bathroom policy for North Carolina? Right? If you don't let North Carolina and these other states go their own separate way, or California go its separate way on crazy things it wants to do, you're gonna force a national one-size-fits-all solution that will never be stable enough to survive.
Okay, I agree with that, but also it's not that the country is too big, but that the states, many states are too big in terms of the ratio of the largest to the smallest, and also Congress is too small. We shouldn't have a congressman representing 1 million people or 800,000 people, whatever the average is these days. And you know, Canada, for example, I was watching, I'm Canadian American, I'm one of the few people that you'll meet who's naturalized twice in his life. And many of you have probably heard me make my immigrant joke that, like most immigrants, I do a job that most native-born Americans won't, defending the Constitution. Present company excluded.
There you go.
But I was watching the Canadian elections a month and a half ago, and the Canadian Parliament is the same size as the House, and that's a country 1/10 the size of the United States. So here I am from Cato, and I'm telling you there should be more people in Congress, and they'd probably be the staff should probably be paid more as well. It's a, you know.
I apologize. We're not going to be able to take our last question. Please join me in thanking and appreciating our panel.